Good morning. Thank you very much for your presentation. Only a very little correction about my condition of constitutional law professor, not international law professor. Thank you very much for the invitation to the agency to attend this conference, and especially this session on protecting privacy in a fast evolving, more complex digital world. If there is one sector in which the need for a rapid legal response is particularly important, it is new technologies. In this digital environment, we are not dealing with a revolution, but with a constant, rapid evolution. While technology has clear and obvious advantages, its widespread use also presents challenges. For this reason, we need to reflect on the challenge that we face, on which agents are involved, and how we can protect privacy appropriately. In my opinion, we can identify three challenges in this digital environment. Firstly, the rapid development of tools that allow mass use of information in a more perfect way, and that offer a multitude of information processing possibilities. This results in at least two knock-on effects. First, the possibility to store, process, and transfer large quantities of information, which has contributed to the high economic value of these services. On the Internet, personal information is a leading source of wealth. The most obvious example of this can be seen in advertising being individually tailored according to our browsing habits, behavioral advertising. Two, omnipresence is another phenomenon in this field today, which can be seen the convergence of Internet services with mobile technology. Another challenge that we face is the transnational nature of these services. Companies operate in dozens of countries with different legal frameworks. At the same time, data are no longer kept in a specific location, but are rather spread among hundreds of servers around the world, as is the case with the cloud computing. And last but not least, the Internet gives everyone a presence and a voice. The digital world has changed the role of individuals. People have also taken on an active role, which poses a challenge to current privacy regulations. People express themselves in blogs, microblogging networks, or they share their experiences on social networks. All of these factors, together with the increasing complexity of society, technology, and business structures, lead us to consider the nature of the roles and responsibilities of users, business, and government. The clearest example of the complexity in assigning responsibility can be found in online social networks. When publishing information on a social network, who is responsible? The Article 29 Working Party, maybe you who doesn't know, the committee created by the Data Protection European Directive, the Article 29 Working Party has looked into this situation and come up with a series of criteria. A paradoxical situation arises in which an individual becomes both the active and passive subject, making decisions on the information they process. This means such a person may be considered the processing controller in the terminology of data protection legislation, subject to the same obligation as controllers. It is important to clarify that data protection legislation excludes data protection carried out by people carrying out exclusively personal or domestic activities. The Article 29 Working Party has set out some situations in which processing by social network users may go above and beyond this domestic activity exception. The first situation is when the user uses the social network as a collaboration platform for an association or company for commercial, political, or social purposes. Another sign of the domestic scope being exceeded is when the user clearly has more contacts than could rationally be considered to be real contacts. For example, when a user has willingly allowed a large number of contacts or a whole social network to access their data. There is a third important case in which a user may be considered to be a data processing controller. This is in cases where processing of other people's data violates these third parties' rights. In other words, the domestic activity exception is also limited by the need to guarantee rights, particularly in relation to sensitive data. When any of the aforementioned circumstances arise, individuals are obliged to offer certain security guarantees to ensure the confidentiality of the information published and to offer measures for users to exercise their data protection rights. But businesses have also played a fundamental role. The complexity of businesses that operate on a global scale and that outsource services must also be studied. It is important to determine who is in control of processing the data, that is, who determines the purpose to which it will be put, as this helps to ensure greater effectiveness in compliance. The tendency in data protection regulations is to combine proactive and reactive measures to ensure compliance, which may include self-regulation measures. Reactive measures are applied when data have been processed unlawfully. I would also like to mention the principle of accountability. This principle, which was included in the Organization for Economic Cooperation and Development's privacy guidelines back in 1980, requires the processing controller to implement appropriate and effective measures to implement the principles and obligations of data protection. This, firstly, involves demonstrating compliance externally, and secondly, an internal process to create control mechanisms to ensure compliance. It must also be possible to demonstrate this when required to do so by authorities. The Article 29 Working Party has suggested that the European Commission should consider the possibility of including this principle of accountability in the review process of the Data Protection Directive. Companies are responsible for respecting the privacy of their clients and users. For this reason, companies have been called on for some time now to take an active part in designing these services and platforms. One example of this can be seen in privacy-enhancing technologies. The Data Protection Directive establishes the processing controller's obligation to put in place technical and organizational measures that will guarantee an appropriate degree of security. These privacy-enhancing technologies are technological measures aimed at protecting the right to privacy by deleting personal data or preventing data from being unnecessarily processed. These systems have been supported by the European Commission.